back. We'll get started. We're going to have two speakers in this next panel that will be presenting in tandem with each other. But I want you to just think about, we've progressed. What we're doing today is we're establishing a foundation for how we address the whole world of disability. And so in essence, we're just barely laying the foundational build that we can move forward, because I agree so deeply with the individual who said, why is the faith community not stepping up? And I think that is one of the catalysts as to why this conference is even happening, is because we've seen those issues come up way too often in our community. And so that is why we're saying let's be problem solvers and let's move forward to try and move forward into a deeper conversation. And so we've just scratched the surface of what the theological assessment might be. And now we're going to lead into the legal assessment, because then in conjunction with all of those implications that we've talked about in the first session, we need to also consider the legal side. And so these two individuals will be able to lead us through the beginning of that conversation together. So there will be no interruption between theirs, that will go straight after they're finished into some Q&A. So again, write down those good questions and we'll have time for that. So let me introduce our panel. Christy Martin, which is sitting here, is serving in disability services as the ADA officer at Multnomah University since 2011. During this time, she's been able to advocate for the needs of students impacted by disability, both in the classroom and out. She earned her master's in education leadership and policy from Portland State University and a BA in biblical studies from Life Pacific College in Southern California. In her graduate studies, two areas of focus that Christy chose were universal design and student success. She has a passion for equity and will be presenting on the ADAAA and Section 504 policies and how that pertains to students in college as well as to the general public. Thank you, Christy, for being here today. And then our other guest and presenter is Ian Jake Est, and he is involved in the affirmative action and equal opportunity development at OHSU. Ian is the interim ADA coordinator at Oregon Health Science University. As the ADA coordinator, Ian works across OHSU, addressing issues related to making the enterprise more accessible for people with disability. Ian also conducts trainings designed to help foster a climate of greater inclusion for people with disabilities. Since joining OHSU in the summer of 2014, he has conducted more than 300 trainings, reaching more than 3,500 people. Prior to OHSU, Ian worked in a variety of fields ranging from journalism to professional sports. And Ian has a Juris Doctorate and a degree in English. Let's welcome our panelists and let us go.
Here we go. Thank you so much. We are going to talk about, let me see how I can get my clicker to work. Here we go. Legal assessment and advocacy. I'd like to open by saying that this is one of the most boring PowerPoint presentations you will ever be subject to witnessing. There are plenty of folks who have major issues with PowerPoint and accessibility in general, and I did not do a whole good job of making this any better. But let me assure you that if this is not highly accessible for you, you are not missing much, and all the words that are on these slides will come out of my mouth. So here we go. The most exciting thing about this PowerPoint is that the background on the current title slide is blue. We switched to gray very quickly here. And this is as good as it gets, folks. Okay, let's just start talking. And Ian and I are both gonna just kind of dialogue as we go through these slides. So I want to present to you what some of the federal guidelines are and legal requirements for employers and education, the field of education. They started with Section 504 of the Rehabilitation Act in 1973, which focuses on rehabilitation and accessibility. It was the first disability civil rights legislation to be passed. And prohibits discrimination, and that's the focus of that legislation, is the prohibition of discrimination against people specifically with disabilities.
So I think one of the interesting things about Section 504 is the date that it passed. So what I like to say at OHSU is that the history of disability is short. It's relatively new. So that in the history of the world, our first law around disability was 1973. So this is a new science. It's a new study. It's still relatively new law. So I think that one of the jokes I like to make at OHSU, and you right away will see if I'm funny or not, is well, now I've lost my train of thought. That's how funny I am. Thank you. Thank you very much, Christy. That's an easy target there. Is it's something around that disability. This is a new study what here's the joke is if you're going to acquire a disability, that you're doing it now is smart, because it's the best time that's ever been to be a person with a disability. That is the definition of a mercy laugh. Thank you very much.
Yeah, I think that's also why you see educational institutions and employers still wrestling a lot with how to implement ADA and Section 504 institutionally, because yeah, we're still wading through this, and not that I think we're ever going to arrive at a certain point, but that's so true. This is pretty new. I still haven't nailed where I'm actually supposed to point this. That worked. Okay, so that leads up to the Americans with Disability Act, ADA, which was in 1990. The goal was to have a clear and comprehensive mandate regarding anti-discrimination against persons with disabilities, and it formally recognized the rights of persons with disabilities, that people with disabilities have a right to fully participate in our society. So those are a couple key pieces that were important with that.
I think it's again key to look at the date, 1990, when we were able to fully participate in society, where we would have that expectation. The great thing about the ADA was that it created an opportunity. Right? It was supposed to not give us jobs, to give us educations. It was supposed to give us the opportunity to have jobs, to give us the opportunity to participate in programs.
Yeah.
So think about that. That's a huge promise. That to basically before that there was no promise, but now there is a promise. Yeah. Okay, and if you dive into the statistics a little bit, what you would see when that law passed was that people with disabilities had been historically the least educated, because it was tough for people with disabilities to access institutions of higher education because they're old buildings, right? It was tough for people with disabilities to have jobs because it was tough to access buildings. In 1990, that was all supposed to change. ...
What it required, ADA, these are some of the requirements. So again, prohibited discrimination based on disability. And this was specifically focused on employment, education. Section 504 and ADA they tie together. So education in that field still uses ADA. It affords protections to persons with disabilities, similar to those protections that were afforded under the Civil Rights Act for various other groups of persons. It required employers to offer reasonable accommodations, and we'll talk about reasonability later. And it imposed some prescribed accessibility requirements, as people are constructing new buildings or modifications that they needed to make to current buildings. It actually putting out some concrete minimum guidelines for that.
It's interesting, the ADA creates better access to buildings than it requires access to jobs. So what I mean by that, where I work, it's more important to have, at OHSU, we try hard to make the buildings accessible, to get into the building, to get access to the services. We're not necessarily required to try as hard to make the work areas accessible, right? So there's an inherent bias in that, because you have this expectation that you can get in the building. You don't have this expectation that you can necessarily work in the building. And that's true for everywhere. I'm singling out OHSU because that's where I work, but it's basically true for everywhere. I've been in medical offices around the country where I couldn't work. I could be seen there sometimes as a patient, but I couldn't necessarily work there. And I don't have a medical degree, and I know nothing about medicine or the practice of medicine. But what I do know is that in the back of house, so where the staff works, would be impossible for me to work in a lot of those places because I can't use the restroom in those places, right? So think about the message think about the message that delivers to people with disabilities. I can aspire to be whatever I can aspire to be, but can I actually work there? The ADA requires that I can receive services there, right? So I could go to, again, using a medical office as an example, I could go there to be a patient, most likely, but I probably couldn't work in that medical office because I couldn't fulfill my daily living expectations, what I need to do, right? So there's a message in that we try to overcome every day. It's a struggle though. So I'll stop talking now.
No, that's good. ADA put a definition to disability, which was a physical or mental impairment that substantially limits one or more major life activities, a record or past history of such an impairment, or being regarded as having a disability. So we'll talk a lot more about how this definition of disability, has been, used both positively and negatively. But that was a part of the ADA legislation, which kind of gave us groundwork for defining. Oops. I'm doing terrible at this. Okay, so something that was we were having problems with in ADA is that courts were beginning to focus on the evaluation of whether or not a person had a disability, in particular, like in lawsuits and cases, rather than focusing on whether or not discrimination had taken place. So in 2008, some legislation was put in place to clarify how the ADA was to be interpreted and how it was to be applied. They broadened the definition of disability. So they said, hey, they didn't change the definition of disability, but they said limiting a major life function doesn't just mean you can or can't get into a building. That could be your ability to concentrate. That could be your ability to sleep. That could be your ability to, I'm saying focus, which is concentrate, but they really broadened that out and said a major life function encompasses a lot of different, both concrete and more cognitive and emotion-based things, right?
So there are 28 major life activities, and I will give $1 to anyone who can name those 28.
I got 2, and I'm sitting up here, so.
But you're all doing,
Whoops.
please rest assured, you're all doing a lot of them right now. Sitting is a major life activity. Breathing is a major life activity. Seeing, hearing, speaking, working, driving, all these things. So it's don't overthink what a major life activity is. You're doing a lot of them right now.
It also, so with broadening the definition of disability and making sure that legal systems were not narrowing that focus too much, it also said you shouldn't be requiring extensive analysis in order to establish whether some or not someone has a disability. So We'll talk a little bit more later about documentation, but people were requiring extensive documentation or saying, well, even with a visible disability, which there's, we've got visible and invisible disabilities, but even with a visible disability, saying, well, unless you can give me documentation that this is a problem for you and how it impacts you, we're not going to spend the money, take the time, put the effort into getting you the accommodations that you need. So they said, no. That should not be something that people have to jump through tons of hoops to simply get their basic needs met.
Think about the messaging in that. In that there's an inherent bias towards people with obvious disabilities, right? So to me the perfect example is parking and the struggles that the city of Portland and the state of Oregon have gone through to change the parking rules for people with disabilities. It used to be that there was one type of parking spot for people with disabilities, and you know what I'm talking about, the blue sign that indicates parking for people with disabilities. So there was this general feeling in society and government, and it's not just Oregon, it's nationwide, that a lot of people were gaming the system. A lot of people without disabilities had access to a placard, so they would hang the placard and then use that parking, because I'm going to be honest, we get great parking. It's one of the perks. It's one of the great perks. It's why I have so many friends.
Get you good parking.
Finally a good laugh. So what happened was that they changed the rules, so that now people who use wheelchairs, thankfully me, we still get the great parking. But if you don't use a wheelchair, you don't get as good a parking, and now you have to start paying for parking, right? The rates aren't the same as people without disabilities, but they are still. It's a hassle. It's a difficulty. It's one that people without disabilities get to experience all the time, but it's an extra burden for people with disabilities. So the problem that I have with that, I have lots of problems with that, but primarily, how can you tell if a person has a disability by looking at them? You can't, right? And there are lots of people with disabilities, even in this room right now. Now, I think that I'm the only person here in a wheelchair. And yes, it is a cool wheelchair with black spokes. I'm all about style. The black is slimming, by the way. Thank you for that. So what happens there is that's a discouragement for people who may have a struggle, may have a need, may have a greater need than somebody in a mobility device to park closer. If a person had anxiety related to being in the outdoors, and they really needed to park as close to a building as possible so that they were outside very less time, but they had to park farther away, and then they had to keep coming out to feed the meter, that would be a disincentive for that person to go outside, right? But there's this bias. If you can't see it, it's not real, right? Now and I put 100% of the blame on the international symbol for disability, which is the person in the wheelchair. I was the model for that back in the 70s. It usually gets a better laugh. But I think there's a bias in there, and there are lots of ideas around how to change that logo, but there's not really any movement toward that yet. So it's important to take somebody's word for it, I think, and that's one of the great things about the update in 2008 is that it starts to do away with that bias.
I'll just interject it here also. I think that bias has been created and fueled, and with it, maybe as a result of it, or maybe it's separate, I don't know. I think that folks in general in our society are a lot more open and feel like they maybe know a little bit more what to do with a mobility impairment if they know that your cognition is not impaired or something like that. But when it comes to cognitive impairments or emotional impairments or just differences, I think majority culture we don't know what to do with that, and it's muddier and harder. So it's like, oh, you're in a wheelchair, you need more space to get out of your car. Sure, we can do that. But it gets muddy when it's like, well, why are you so afraid of the outdoors with that anxiety? You know, well, what's wrong with you that would be a problem for you? And it's a lot easier to start to blame the person rather than looking as a society at, well, what's going on, and also just medically or with health stuff, you know, what is fueling that, right? So the last thing with the Amendments Act is did I do that already? Focuses evaluation on whether, oh, yes, so in the court system, I think I already mentioned this. Many courts were just focusing on whether or not someone qualified as having a disability to determine, you know, a case. And they were saying that shouldn't be the focus of your case. The focus of your case should be evaluating whether or not discrimination took place. So we're not going to focus on, did this person qualify as having a disability in the same way? We're going to say, did discrimination take place? Because that's what this law is ultimately supposed to be about, is anti-discrimination. Let's all just awkwardly wait until I figure out this clicker again. Hang on a second.
You can say clicker and they can help you.
What was that?
Tell them clicker and they'll change.
Clicker. I don't know. Oh, yeah, I'm sorry. Thank you. That would be lovely. Yeah. Okay, cool. No, that's great. I bet you are. So just at a glance, I put up a brief policy comparison. There's between ADA, IDEA, which is another body of law that we're not discussing here, but it is an important piece, and then Section 504. So ADA, civil rights law to prohibit discrimination solely on the basis of disability in employment, public services, and accommodations. IDEA is a body of legislation that focuses on children with disabilities, an education act to provide federal financial assistance to state and local education agencies to guarantee some special education and related services to eligible children with disabilities. So special ed classes and accommodations in K through 12. IDEA is a major piece of legislation that guides their practices. And then Section 504 is a civil rights law to prohibit discrimination on the basis of disability in programs and activities, public and private, that receive federal financial assistance. And that's where you get a lot of higher ed institutions participating or using this legislation, because most higher ed institutions, like vastly most, like maybe not one in the US or something, is getting federal financial aid. See, it's harder than it looks. I'm just going to put that out there. Oh, no, that might be right. Okay. Oh, see? Yeah, I know. Okay, so providing accommodations. So under Section 504 and ADA, again, there are some specific accessibility requirements when it comes to building access and turning radiuses, things like that. But then there's this huge ambiguous body of employers and institutions have to provide reasonable accommodations. So the question becomes, well, what does reasonable mean? And this is how they kind of define reasonability under ADA in Section 504, that it does not pose a significant risk to the safety or health of others. So I'll give you an example of that. So for instance, if a student, and I work in higher ed, so all of my examples are higher ed for students. But if a student were to request an assistance animal or an emotional support animal in campus housing, one question that comes up is, could that animal pose a significant health risk to someone with severe allergies? So that could be a thing that we would need to work out. We've had a case where we had an assistance animal and we had a person with severe allergies. They ended up hospitalized with pneumonia, and that stuff happens. I'm not trying to minimize the fact that someone got pneumonia and that was horrible. Didn't mean to say that. But institutions and employers do have to wrestle with that. Then how do we manage that? The approach should not be this could pose a significant risk, but rather that it does pose a significant risk. So, well, it's possible that someone here has an allergy, so we're just going to say no automatically. There is an onus on the organization to investigate to find out, is there someone with an allergy that's severe that's living there currently that this is going to potentially harm, right? So we have to do our due diligence to actually say not just risk avoidance, but like in reality, how is this going to impact our current living situation or people that are here?
Because the allergy could be a disability as well. So
And it qualifies as a
right,
disability.
It could.
Yeah,
right,
it could.
Absolutely.
Yeah. Yeah. And so with that, so for just taking that example farther, it would be hey, we're looking at having an animal in a building, and is there anyone who would then maybe provide documentation that would say, I have a substantial allergy, not just I have an allergy and I would have to take Benadryl every once in a while, but where it actually poses a risk to my health, and then that could be evaluated. Another point in determining reasonability is that it shouldn't fundamentally alter a program or service. So for instance, in higher ed again, our degrees are based on learning outcomes. If you earn a degree from an institution, it should mean that you have reached certain learning outcomes. That is fundamental to our program. What our faculty do is they determine activities or exercises that students are able to participate in to reach those learning outcomes and to reflect whether or not they've reached the learning outcome, right? So I explain it to folks as we've got these learning outcomes up here, and then our faculty and our programs are carving a path to reaching that learning outcome. What we have to be careful about is not thinking that the path itself is a learning outcome, because it's not. The path is just a path. We need to be flexible on the path to reaching the learning outcome, but that doesn't mean that we're compromising the learning outcomes. To do so would be a fundamental alteration to our programs. Does that make sense? Do you want to add anything to that?
No, I'm good.
Okay. Another point in reasonability is that it should not result in an undue administrative or financial burden to whatever the organization is. This one, administrators, at least in higher ed, are like, well, what does that mean? Give me the dollar amount, right? And it doesn't exist. That is undefined. So it is a case-by-case evaluation of reasonability. Does it seem like, based on whatever the particular organization's administrative capacity and financial capacities are, that whatever accommodation we happen to be talking about is vastly beyond the capabilities of that organization? But it's an individualized assessment.
And it's the organization, not the department. So we sometimes struggle at OHSU in providing accommodation for employees, where the department will say we just can't afford to provide that. That would be an unreasonable burden, and they say would meet the threshold to deny the accommodation. That would be an unreasonably expensive burden or arduous burden on our department, so we can't provide it. But what the courts have said is it's not about the department; it's about the institution. It's not going to be. You have to weigh the reasonableness against the assets of the institution, not against the assets of the department. And that's a great thing for people with disabilities at an institution like OHSU or a bigger institution that has a lot of resources. And that definition should have been very helpful to get people with disabilities more opportunities to be employed. Should have.
Doesn't always, unfortunately. And then lastly, the last determining factor in reasonability is whether or not the accommodation is personal in nature. So for instance, in higher education, our responsibility is to make sure that the student has access to all of the information and all of the programs, like all the social opportunities and all the information that they need. and that they would have forms in which they could communicate their learning back to us in a way that is meaningful and works for them. If a student, for instance, needed a personal assistant 24/7, it wouldn't be the institution's responsibility to provide that accommodation for 24/7 care. They would be responsible for providing access to the programs and information that they're offering, and then again to also figure out ways that work for the student to communicate back to the institution their learning and their participation.
Great. So let's talk about reasonable accommodations in broad scopes. I think that the reasonable accommodations are a great concept, perhaps poorly named. I think that there is a fear that employers and academic institutions have around the idea of reasonable accommodation. They assume that all people with disabilities need reasonable accommodations. So I'd like to, since we're at a institution of higher learning, offer a little quiz to you today. So it's a 5 or 6 question true or false quiz. True or false, all people with disabilities need accommodations. False. But true or false, most people with disabilities need accommodations, whether it's academic for learning or whether it's in a job setting. So true or false, most people with disabilities need accommodations to perform the essential functions of their jobs. Most people. True or false? False. False. In fact, it's way less than half. But going back to the quiz, all accommodations cost money. True or false? False. All accommodations, though, that do cost money are expensive. False. So on average, that's the end of the quiz. You all did really well. On average, the reasonable accommodation in an employment context in this country costs $400. Ouch. Now, to some people, to some institutions, that might be a burden. That might be unreasonably expensive. $400. And that's fine, then the accommodation would be denied. But most accommodations don't cost any money. There is this fear that all people with disabilities need accommodations. So we were, and speaking on behalf of my people with disabilities, we were really excited about this clause because this was going to be a game changer. This was going to change that statistic I mentioned. Oh no, I mentioned earlier that people with disabilities are still the statistic was that people with disabilities, when the ADA passed, were the least employed segment of society. Now, almost 30 years later, that's still true. There is this fear, I think, around accommodation. So in a way, it's great. In a way, accommodations are great. In a way, they've been disruptive.
Let's flip. Let's see what's next. I think we're getting close to the end here. No, yeah, right. The previous slide. Yeah, here we go. So that's a great segue into, if you haven't picked up, accommodations are ambiguous. The legislation behind accommodations is very ambiguous. That's on purpose because everybody is a person who, with their own needs and disability or limitations, look different. You might have the same disability, but someone wears it totally differently. It impacts them totally differently. So walking into ADA in Section 504 is innately kind of an uncomfortable thing for a lot of people because it's not concrete. It's something that is ambiguous, and they have to be okay with that ambiguity to say, it's going to be a conversation. So when someone requests an accommodation, the answer is never simply, no, we don't do that. The answer is always, let's have a conversation about it. And the legal requirement is that organizations, institutions, employers would engage in that conversation and have a conversation. I think we're close to the end here. Documentation we already talked about. There is a de-emphasis on requiring documentation nationally, and it is most appropriately used simply for identifying how a disability is actually impacting this particular person. that documentation can help you come to what are appropriate accommodations in this situation, and that can be really helpful.
It can also be a method of outing someone, of having a type of disability or having things related to disability that can be uncomfortable to disclose. Right? So it's a balancing act. So lots of people where I work, lots of people who have disabilities do not disclose that they have disabilities because there's often a stigma attached. There's often a fear attached.
Sometimes when I'm working on accommodations and I'm afraid I'm going to get some pushback, I remind the institution that if we are going to lose a lawsuit, it's going to be because someone said they needed something and we didn't do anything to help them get their needs met, not because they didn't provide us specific types of documentation. Like, that's not how places lose lawsuits. It's by not being helpful. Oh, nice. Yeah, and then just note episodic disabilities. This slide says also totally a thing. Some disabilities only impact people for a certain amount of time, but while they are being impacted by that thing, they still qualify as having a disability under ADA and Section 504. Ultimately, you can't change the way people think by creating policies and legislation. And this slide also says these policies are ambiguous for a reason, which we already talked about. We have to go deeper than just minimum legislation in order to actually meet the needs of persons impacted by disability and in order to make some actual progress toward equity, right?
So I want to leave you with this thought that there are lots of people with disabilities. 20% of the population, 1 out of every 5 people in the world has a disability. Okay, and disability is often perceived as a burden, whether you have the burden or whether the burden is somebody else's issue, and that makes it your burden. People with disabilities are often ignored or are rarely or sometimes not included at all. I want to leave with you 3 things that people with disabilities have contributed to your life that you use every day that benefits everybody that we don't get credit for. Okay, one is the curb cut. Right? Almost everybody uses a curb cut at a sidewalk to get up onto the sidewalk. Okay? The other is the automatic door. Right? We don't all need to use them, but we all use them. Right? And then the third one is a little bit more delicate, and I don't want to talk about it too much, but it is the wider bathroom stall. Everybody likes a little more room. So I want to say to you today, in closing, before questions, on behalf of people with disabilities everywhere, you are welcome.
That's awesome.
Christy, Ian, thank you so much. And Paul, I'm going to have you come up and grab one of their mics, and they'll share one. I'd like you to try and share your questions at this time. I want to take a note, is that in one of our sessions after lunch, we're also having a pastor share of how does this whole conversation impact even their church building. So just know that that will be addressed at a later time as well. So Paul, go for it.
I have a question. You talked about access to information for making accommodations within, and this was basically in a higher education situation. An individual has access to the information of their accommodation, correct? Did I understand that correctly?
Let me give you an answer, and you can tell me if I'm answering your question correctly. So I was talking about access to information that the institution is presenting. So,
Yes. So any information that the institution would present within the institution, the person would have access to that knowledge.
That's the idea.
Okay. Within the institution, when there are various parts of an institution, being a mother of individuals with disability, funding comes from many different sources. And so individuals with disability need to have information about all of that. Is that my correct understanding, that that law allows them to have information based on their situation?
about where the funding is coming from?
Not so much the fund, yeah, I guess from the funding, in relation to the funding.
Not necessarily, not specifically. I think that's more of talking about, and maybe you could help me address this, but that's more talking about the transparency of institutional funding and things like that. An example of what I was talking about with access to information, I'll give two brief examples. One would be, for instance, classroom lectures, which are important to the learning outcomes. If a person has a back injury and they have a 4-hour class, they can't sit in one of these chairs for 4 hours and make that work for them. So that's a very simple accommodation of like, let's give you a bigger chair and also let your faculty member know that you might stand up and walk around, and that's cool. And not to treat that like a distraction, right? Or maybe on the more, a greater accommodation might be someone who has severe social anxiety or severe depression, an invisible disability that's already going to be harder for people to notice and accommodate. And we might be talking about being able to record class lectures or have a friend take notes and you have access to those notes in a formalized way, things like that. It also could pertain to programming of the institution, like chapel, social events, like those are also expected to be accessible.
I was actually curious. I come from a family where both my parents are ADHD and have PTSD, myself included. And for years, I remember going to school and dealing with the frustrations of accommodation, be it IPA and otherwise. And I was just kind of curious, since you're coming from institutions that are both, educational, I am curious if the question of time has improved at all. Because I remember when I was in school, unfortunately, there was an emphasis not on whether you actually know something, whether you have the capacity to reason properly, whether with adequate time you can demonstrate that in a meaningful way, but that faculty oftentimes would have a substantial bias and believe that if we give you extra time, it would be unfair to the other students. And unfortunately, I saw that as a continual theme amongst faculty. And I'm curious if that's something that has improved with time or if this is still one of those fundamental quandaries of the academic.
I love that question. I have a lot of feels about that question. I think, I can't speak for a lot of other institutions. I run disability services here. I think that's one of the things that I try the hardest to work on is time. I've had students with unlimited time for testing accommodations, and I've advocated for that. I have talked to faculty about, okay, is the time a part of your learning outcome? Like, does it matter that they get this done in a certain amount of time, or is it about the information that they have inside their head, And we've talked through that, even talking about verbal exams versus written ones or different things like that. I do think that there's a fundamental barrier in higher education to time, which is that we have a semester that starts and ends. We can give extensions, but then we have another semester that starts. So sometimes I think a competency-based program is a better fit for people who have the ability but don't have the time, because then they can work more at their own pace and they don't have those the structures that are inhibiting their ability to take the time that they need to get things done, the beginning and the end of a semester or a course.
Yes, this is also on the legal front. Since Oregon is a state that has a no cause, I'm not sure I'm using the right phraseology, for firing people. I know of two people who have with more silent disabilities, one with fibromyalgia and one with migraine, who have lost their jobs after many years because they've had to take breaks due to these disabilities, and they know they've lost their jobs because of this situation, but you know, of course, something else is written down and now they are no longer employed. How do you address this?
So that's a great question. I try to encourage, through my job at OHSU, every employee who thinks that they might need an accommodation, if they have a disability, to start the process now to get that documented as soon as possible, so that that doesn't happen. So that the institution is aware, the manager is aware, the department is aware that this person has a disability and may need accommodations to address issues related to that disability.
The hospital where she worked was aware that she had fibromyalgia, and she was a nurse there for 30 years.
So I'm sorry that happened. It's a matter of having enough, I guess, allies on your side so that the law is being enforced as it should be. On those facts, it doesn't sound very good for the hospital. On those facts, and again, I'm sorry that happened, but it's a matter of working with, at OHSU, it's the Affirmative Action Department. It might be an HR thing. At other places, it could be a legal issue at some places that the legal department would address. So it's just but it's a matter ultimately of documenting, and protecting your rights, so that if something like that, you may have a cause of action. Your friend, your associate may have a cause of action after that happened.
Thank you, Christy and Ian, for your sharing. And I know that this is a very technical issue, and as you can tell by the dates, it's not one that's been resolved very long ago, and it's still not resolved, and it's still being defined, and there's still vagueness as to how this gets applied. And so, in result of that, I'm sure that there's questions that you're going to go, "What about this? How can this be addressed? How can we?" Continue this conversation, because honestly, this is just the very, very beginning. And so I would encourage you to write down your questions, and I'm going to kind of give a highlight that the really exciting thing about this conference is that this is not the beginning and the end of this conversation. As you can tell by some of these weighty issues that we're considering, whether we're in secular or in sacred, we're looking at a framework, a posture, and an approach that is encompassing and has got to be broken down so that we have more health and love and grace in all of our environments. That being said, one of the things that we here at New Wine are trying to do is to continue this conversation. So each of you that have email access to us that we've gotten from you, we're going to be sending out a survey. And in this survey, it's going to address whether you're an individual with disabilities, a family member with disabilities, a church, or an agency, service, or organization, to tell us where the gaps are. Because we see those gaps happening, and so we want you to be a participant in that. And so you will be receiving that. So you will continue to have a voice in this conversation. So any of those questions that come through the day, go, "Oh, I wish I could have asked that," they still can be asked. So write them down, note them, respond to us, because we know that we have huge gaps in our communities that are not addressing this in an effective way. So again, thank you, Christy and Ian, for being a part of that we sure will have further conversations with you in the future. Well, that being said, I think we have a need, and that's called nutrition. And we invite you to join us for lunch. You don't have to go very far. You just have to go to the plates at the beginning of our buffet section right here. And so you can grab a plate, choose whatever you want. And I really would encourage you that if you have a dietary concern or a question, please do not hesitate to ask us or the staff, because they tried to make it as accessible as possible. And so feel welcome to ask the questions. They'll be ready in 5 minutes is what he's telling me. So in 5 minutes, that gives you time to wash up, and to get your bracelets and to network with Ask Questions. And we will rejoin promptly at 1 o'clock. So this gives you some fair bit of time to get some fresh air, get some beverages, and network and talk to each other and ask questions. So have a great lunch. And why don't we just pause for a moment? I'll pray for lunch and we'll go from there. God, just thank you so much for letting us be here together. Bless this time, bless this food, bless this time to converse on a difficult issue, but yet exciting. Thank you that you've opened this door and let it not end here. We pray in Jesus' name. Amen. Enjoy.